Good evening. This is the September 14th meeting of the Zoning Board of Appeals. First up,
Appeal 2023-040, Robert Lepore, cabin 84, 3010 Holst Landing Road, Wading River, Suffolk County Tax Map Number 600-37-1-1, RB40 zoning, proposed relocation of existing bungalow. Applicant requests variances and/or relief from Chapter 219-14A2, where proposed relocation for reconstruction of existing bungalow is not specifically allowed development under Chapter 219-14, Section B. All development in the bluff area is prohibited unless specifically allowed by Chapter 219-14, Section B. This was adjourned from August 10th, 2023.
Excuse me, Tracy?
Yes.
Hey, Larry, is that mic on? Did you hear that out there? Her talking? Good.
I believe you've been sworn in before on this matter, so
Yes,
please-
so I'm here just to report that...
Good, well,
Vic-
just think, slow down.
Yeah.
State your name and your address, and then we'll hear whatever you have to say.
Okay, it was just going to be 30 seconds. Vic Pershnowski, 533 Elton Street, Riverhead, representing Mr. Lepore, 3010 Holst Landing Road. As you remember, we had a neighbor who asked a question about liability protection of the other property owners, and after that meeting, I secured all the documents that he already signed. It's a policy of Oak Hills that any work that's done in the association, you must sign indemnity clause. They have a list, which you have, of conditions they have to adhere to, and there's something called a building permit application, and they have to provide insurance, indemnity, and protection. So, and I also, Mr. Barnes made sure that I emailed it to the neighbor, which I did. So we answered that question fully. And we would ask that you approve the variance so we can move the house, because it's 2 feet to go before it falls off the cliff.
Let the record reflect that I have a copy of the building permit agreements referenced by Mr. Krasinski.
Right.
Thank you, Councilman. Any of the board members? Leroy?
Is there anybody else here that wants to say anything about it before we vote on it? Okay, so I think I'll try to read the resolution. So I move that the appeal of Robert Lepore, cabin 84, 310 Holst Landing Road, Wading River, tax map number 600-37-1-1. It's located in the RB40 zoning district for variances and relief from Chapter 219-14A2, where the proposed relocation, reconstruction of existing bungalow is not specifically allowed development under Chapter 219-14, subsection B. All development in bluff area is prohibited unless specifically allowed by Chapter 219-14, subsection B. Be approved in accordance with applications and sketches with amendments thereto, if any, filed with the building inspector.
So moved.
Are you a second?
Second?
All right, okay. Mr. Gazillo?
Aye.
Mr. Barnes?
Aye.
Mr. Whitmire?
Aye.
Mrs. Zawiski?
Aye.
And I vote aye. So the appeal has been granted, and
Thank you, gentlemen.
you know the process.
Appeal 2023-035, Driftwood Family Farms, LLC, 3795 Middle Country Road, Calverton, Suffolk County Tax Map Number 600-117-1-3, Industrial C zoning, interpretation of code. Applicant requests to appeal code enforcement determination and action, issuance of stop work order, appearance ticket number 6291, which is asserted to be issued in error because of the continued agricultural use at the subject property, and alternatively based on the determination of the ZBA number 09-58 interpretation finding that the applicant has vested rights under the former Industrial A zoning district.
Counselor, if you just state your name and your address.
Yes, good evening, Mr. Chairman. My name is John Armentano. I'm an attorney with Farrell Fritz, 100 Motor Parkway, Hop Hog, New York.
Thank you.
Thank you. We just have some booklets to hand out to help.
You take your time. Yeah, absolutely. If you have something to bring up to us, bring it up.
Thank you.
Yeah, we'll just pass it right there.
Thank you, sir.
Thank you, everybody.
Everybody's happy.
Can't say it'll be a short presentation, so.
Yes, well, do your best, Counselor.
We could always move ourselves down on the agenda, but if it will take me now, that's fine.
That's okay. Take your time.
Again, my name is John Ortano, representing Driftwood Farms. We are seeking, I'm also here with, represent Driftwood Farms. I'm here with Steve Mesneski and his wife Gretchen, as well as Tom Wolpert from Young and Young. As was stated by the call of the meeting, this is a request for an interpretation of the violation ticket issued by the town building department based on issues that we believe prevent that issue from being granted. And we are proceeding under.
There are two issues that you've raised. One, you've claimed a vested right in agriculture, and the second, you rely upon a zoning board of appeal determination number 09-58, correct?
That's correct.
All right, because I want to just keep it to your request for interpretation and not go beyond the bounds of that.
Understood, and I agree with you, and we will endeavor to do that. As you know, we're proceeding under Town Law 267A4, which is the appeal of this ticket, as well as Town Code Section 105-8A, which again allows this board to interpret, rescind, modify determinations by the building department. And what I've handed up to you tonight, I think will help prove our vested rights and how I think this board is enabled to modify or rescind the issuance of the ticket that was given to Driftwood. So if you look at the application packet, as I'm sure you're familiar with the subject property, it is located at 3795 Middle Country Road in Calverton. This is a 2020 aerial indicating the location of the subject property. It is in agricultural use today, and what we will prove tonight is that it has been in continuous agricultural use since the Zay family operated it in the 1930s, I believe. And just for the clarity of the record, Exhibit 2 is the issuance of the ticket, which states is a prohibited use within the industrial C district without the town of Riverhead permits or approvals, and that I think does not apply to the subject property based on our presentation tonight. You'll see as Exhibit 3 photographs of the subject property that were taken recently. It's giving you a view of the property. I'm sure you've seen it. I'm sure many of you have been past it. In these exhibits, you'll also see the state of the agricultural activity. There is mulch and soil being stockpiled on the property as part of the agricultural uses on the subject property. You also notice further on in Exhibit 2 that the fields, about 10 to 12 acres of the subject property, has been planted with a privet nursery stock. It had been left in the sorghum state for soil amendment, and this year my client planted, I'd say 10 to 12 acres of privet in the field for harvest and cultivation to be used for sale from the subject property.
And on what date was that planted?
The exact date?
Yes. A week ago, a month ago?
May of 2023. This nursery stock was planted. Just for the record, I'll clarify, my client has said to me that there was other agricultural nursery stock, and I can attest that there was sorghum in the field as has been proven in the past. This was, and as we know, this is agricultural property that has been placed in an agricultural district. You have the surrounding properties. Just to the north is the Windy Acres Farm. You have a residential house to the east. You have the property which was the subject of the prior zoning grant for vested rights. It's PRG is the owner. They are operating a trade facility with additional prior uses that concrete manufacturing, crushing, and that's being shown that's occurring today, and I think it was granted that vested right by this board, and I'll get to that decision a little bit later, but that's just showing you the existing conditions that surround the subject property. And Exhibit 5 is a notation of this subject property being listed in Suffolk County and State Certified Agricultural District. This is Agricultural District 7. The subject property is clearly in the agricultural district. I think that garners certain rights that come with being located in an agricultural district, and we'll discuss that a little bit later. Exhibit 6 is a survey. Actually, this is the site plan, because we've also filed the site plan with the town. As a result of several meetings that we have had with the town, this property has been the subject of some litigation and some scrutiny by the town, and that's what we're here to attempt to resolve through this process. But as you'll see, this site plan, which was submitted to the town, and we are awaiting comments, and we're also awaiting a meeting with the Ag Committee of the town, shows you the existing nursery, the proposed nursery, as well as the location of where the agricultural soils and mulch will be placed. There's no longer active creation of mulch on the site. The grinding machinery that was once on the site that was the subject of some of the issues that we were having with the town has been removed from the site, and this site plan is being submitted to the town, although it's not before this board, just so for you to understand that we are proceeding with the site plan application with the town as well. And to establish the history of use at the subject property, Exhibit 7 shows several aerial photographs that show the use of the property when it was owned by the Zays. As I'm sure some board may be familiar with, this was a former pig farm that Elmer Zay and his family operated for a number of years. Portions of it were tilled acreage, portions of it were used for vegetable, portions of it were used for hay. There was also the animal husbandry on the subject property, and I think it's clear through the litany of aerial photographs since 1947 that there's been sections of this property that have been agriculturally used, and that has not ceased. And I think the aerials, and we can go through them, 1962 shows very little change, and from what I understand, this is a constant theme on the subject property. There's a 1978 aerial, again showing the tillable acreage of the subject property, which has not changed to this date. We then have an aerial photograph in 2001, also showing basically the existing conditions on the subject property. 2004, again, there's no change in the agricultural use of the property. 2007, 2016, I mean, it's pretty straightforward on the record. And in 2020, the same aerial photograph is there, and I've sent in existing conditions as part of our other earlier exhibits. So in terms of the precedent here, there's also Exhibit 8, which is a building permit that was issued to Roger Zay to add certain square footage to the existing residence. That was granted in 1990. We have a building permit issued to Driftwood Farms in 2022 to renovate the house on the subject property. And I think this one is, the next exhibit is a certificate of occupancy that was issued by the town in 2013 to Driftwood Farms. And it was for the remediation and repair to 4 barns. So I think even at that time, and I know the industrial zone, this was formally,
There's an order going in for
arcane.
Let's go.
roast beef sandwich to go.
Hit the volume button.
Jesus.
So-
Sorry.
so that's-
I'm sorry.
No, that's fine. To this point, the certificate of occupancy was issued by the town to repair 4 barns on the subject property in 2013, which, as we're aware, was after the change in the industrial. This was a formerly industrial A zone property. It was rezoned by the town to industrial C. Industrial C is somewhat unique in that it doesn't provide for agricultural activities unless it's within so many feet of the scenic waterways. And we have an application that is requesting an interpretation of that as well. But I think if this does set a precedent that the town issued a certificate of occupancy for repair of farm buildings in 2013, when that technical use of agricultural activities quite possibly could be no longer permitted under the town code, but the issuance of the certificate of occupancy, I think, reaches back to grant some vesting rights in that this is farming, repair a farm building. So that's the significance of that certificate of occupancy. In terms of the history of the property, again, not to belabor the point, but I think it's merited under these circumstances. Exhibit 9 is a title search that was run on August 31st, 2023, and it lists, and these are in sequence, the exhibits, I think they run out to 20, so 10 through 20, there are 10 exhibits here, and these are the recorded documents of a commitment for agricultural production, which is required if a farm is going to be given certain rights and exemptions from the town. And these date back into the early 80s, and although some of the reprintings may not be clear, it's clearly for the subject property, it's in the chain of title. They were attested to by Elizabeth Zay for a number of years, and they span from 78. If we go through this, they're sequential to the 90s. So there's been an agricultural commitment, and that's what the recording of these easements are. I'm sure you were familiar with these documents. This is a commitment of the land to continued agricultural production. So I know there may be some thoughts that there was a cessation in the use, but these documents prove there was a continuation of the agricultural activity on the subject property, which grants it a vested right because this use was permitted under the old industrial A, and I'm sure was permitted on the original zoning, which we don't have at this time, but the original zone, this entire area was obviously a farmed area, as we're all aware. So these exhibits, again, they are in sequence: 83, 85, 86, 87, 88, and then again in 93. So I think there's a clear continuation of use, a clear burden on the property to remain in agricultural use. So I think that also sets a record and a precedent, at least to give that continual use of agricultural at the subject property.
May I ask you a question? When
Yes.
did your client purchase the property?
My client purchased it in 2013. I'm sorry, it's 2012.
Okay.
And we'll be getting into part of how that linkage
And
continues.
are you aware if in 2012 your client farmed the property?
It was under,
In 2013, did your client farm the property?
Yes, he
And
did.
in 2014?
yes, he did.
Okay. Are you aware of any statements made in public forums at public meetings that the property, by your client, that the property was not being farmed?
I've read the articles that stated that. I know what you're talking
But there's
about.
also transcripts related to an application to
There was a
remove
grading, yes.
sand and soil from the property,
Yes.
which ultimately was denied by New York State Ag Markets and the town board of the town of Riverhead. But in those proceedings, your client stated that the farm was not being farmed, yet he had spent 2 years cleaning up junk and debris from the property.
Yes, and he's here to
Okay.
correct that record, or at least elaborate on that record. I understand what you're saying. There were statements made. I am aware of them. I am very familiar with this property. I've studied the property very, very much, and I'm aware of your involvement with it at that time. Again, to prove the continuation of use, Exhibit 21 is an affidavit from Thomas Funkgeld, who is the property owner to the north of Windy Acre Farms. And in sum and substance, the affidavit is rather short, but in summary, he has stated that since 1989, he knew Elmer Zay, and that when Elmer was on the property, he was actively using the farm as long as he was on the farm until the sale. And in 1989, Mr. Fungeld assisted in crop rotation and also other uses. There was hay, there was vegetables, and other cover crop. And these agricultural activities were continued, according to Mr. Fungeld, until 2008, when Mr. Zay and Mr. Fungeld entered into an oral agreement so that he could use the barns and the barn structures and the storage facilities on the Zay farm to keep some of his product from Windy Acres on the Zay farm. So Mr. Fungeld is attesting to the fact that he was on the property and that he also did disc those fields. And if you look there, and even at the purchase date when my client purchased it, these fields continue to be in a form of a cover crop, which, you know, what is farming? How do you define farming? A field that is in cover crop is still an agricultural use. The cover crop may be returned back into the soil. It is still an act of farming. When you say cessation of use, which is unique, and a discontinuance under the law means the activities have stopped. But I think much the same as a house doesn't stop being a house. It's a residence. It stays as a residence. A farm that's under till or under cultivation or is in some way not completely grown over and reforested still is an agricultural use. So I think even if statements were made that was in disrepair, we know there was some junk on the property. It had fallen into hard times. The property was not being as aggressively farmed in the past, but the fields themselves were still there and maintained. I don't think, you can't maintain them by letting them just grow fallow. Things will grow through that fallowness.
Do you have any proof of sales from 2012, 2013, 2014?
Sales of product?
Yeah.
I think this record may need to be remained open because we can produce that, and if.
Absolutely.
Yes, I think it would.
Record's open.
Yes, I'd like to keep the record open especially if there's a dialogue and we can answer questions.
Okay.
So I would appreciate that opportunity. And then Mr. Fungeld attests that in 2021, he discontinued the use of the farm buildings on the Zay property because Driftwood Farms purchased the property and was going to set forth to rehabilitate the property and bring it back into an agricultural use, or continue the agricultural use in a more aggressive way.
So can I ask you legally?
Yes.
Question. Whether or not you can prove pre-existing use for ag production. This property is in the ag district, is it not?
That is correct.
Would you agree, if the property is in an ag district, it can be used for agricultural production?
Yes.
So, the battle of the proof, whether it was pre-existing versus if it's in an ag district, I don't know why we're going through the exercise.
I agree with you. I wanted to build my record. I have a case to that point. So I agree with you to that point. But I wanted to firm
Okay.
up my record here with a vesting right is one part of my application. The other is the legal end, that in an ag district, you must be able to farm. There's case law that says.
Correct.
Right, so there, and
So the pre-existing non-conforming under law secures your right when zoning changes, right? To continue that use. Whether or not you can provide the receipts and the proof and contradict statements that were made in public forums, I don't understand the point. If the property is in an ag district, which I acknowledge, it is in an ag district, they are able to use the property for ag production. So,
that I agree with. I just want to finish my presentation, but I agree with you 100%. I don't want to belabor the point, but I also want
yeah,
to.
but I don't know why, I feel like we are belaboring that point if.
That's fine. I will be short.
Agree
I will bring this to a close quickly, continuing the record, but I will
Right.
take you very quickly to the next point, and to your point, to answer that question. But I wanted to build my record, and thank you very much. Again, there's an affidavit also when the Kennedys were representing Zay and what was on the subject property. We have the Exhibit 23 of the Statement of Real Properties showing it as an ag exempt property, and those have recently been paid.
So a lot of the proof that you're presenting, would you agree, is prior to your client purchasing the property?
Correct, to continue.
Right,
Yes.
but in order to have a pre-existing non-conforming use, you have to prove that that use continued to the present. So if a pre-existing non-conforming use is abandoned, that use no longer exists. It's set forth in the code. That's the point I'm trying to make to you about not belaboring the point. If it's an ag district, they can utilize the property for ag production.
And that is
But
correct.
not under the theory of pre-existing non-conforming,
It's an-
under New York State law.
Yes, it's an alternate remedy, I agree with you. I was presenting the history, and there's an alternate remedy. I think we can all get to the same point, I think.
Right.
There's an alternate remedy to get there, and that's, again, what brings me to, this is more for illustrative purposes, but Exhibit 24 this was another case that we handled. This was a determination, it dealt with the activities in a Brookhaven farm owned by the Dalia family that had a storage of mulch and compost on the subject property, and it was subject of quite a litigation with the town of Brookhaven. And I'm sure council will read this, but this is an order from Ag and Market saying that this type of storage and storage of compost and storage of mulch is considered an accessory use of a farm and should be permitted to remain, and that was the order of Ag and Markets, which is the state agency. And that case was litigated, and that's Exhibit 26. That case, I'm sorry, the case is 25, and that is the decision of the Albany courts, which discussed this use. And it's been previously submitted to the town, but I wanted this board to have it for its record. And that did find that, because I believe part of the reason the ticket was written was that there was compost and mulch on the property, and that is an associated use of agricultural activity. So I bring this in as precedent and legal precedent for the presumption that mulch storage on the property associated with the farm and with the sale of its product is accessory to the actual farm use on this property, as well as my client's property, Driftwood Farms, out in Orient. So I just have that for the record, more for council than for the board.
So I'm very familiar with that case, very familiar. But your request would you agree that the appearance ticket did not cite a violation due to utilizing the property for agricultural production?
The ticket is a little unclear, but I would say that's
Well, it does not. I don't think it's unclear at all.
Well, it said that the use is not permitted.
And it didn't recite to the use for agricultural production. It cited the importation, exportation, and processing of material.
And what I would add to that, yes, that is the citation, the ticket.
And your request for interpretation was whether or not you had vested rights, or alternatively, relying on a determination of ZBA 09-5E that you had vested rights. Not whether or not, the ZBA is not here. Your request for interpretation is not regarding the importation, exportation, and processing of material. You didn't request that.
Well, as this was, it's an appeal of that ticket, which gives you the authority to, under the town law, you can modify, rescind, or amend that ticket. That ticket is a subject of an issue that we have in justice court, and what we're here tonight for is to have that ticket modified so that the activities, such as the importation and creation of the soil material, is a permitted accessory use to agricultural production. So that's the nexus that brings the ticket and our request for interpretation before this board. So it's kind of it's a multifaceted umbrella approach.
Well, the zoning board of appeals is not going to modify a determination. You requested an interpretation from New York State Ag and Markets, correct?
We have done that as well, yes.
Right? More than once,
There are two different issues, but yes,
right?
that's correct.
And do you have a determination yet?
Not on the second one, no.
And that specifically relates to the importation, exportation, and processing of material, correct?
They both had that component to them. The first appeal to Ag and Markets was under the same, was based on this ticket, and that
Right.
was sent to Ag and Markets. Their determination to us, which I'm sure you're aware, was that we should go through the site plan process, which we are
Correct.
doing, yes.
So what, I mean, I'll let you finish your presentation, but Ag and Markets deferred until you followed the proper procedures within the code that anyone could avail themselves. Essentially saying they weren't going to make a determination because it was premature. Because when you go to New York State Ag and Markets for an opinion, the opinion relates to whether or not the town's code provisions were so onerous, they essentially restricted or prohibited agriculture, true?
That's
why you
correct.
request an opinion.
Correct.
But your client hasn't availed himself of any of the policies and procedures of the code
I would
to
disagree.
date, at the time the ticket was issued, correct?
At that time, the ticket was issued, correct.
Correct, and he has since filed a site plan application.
That is correct.
In addition, there are other provisions of the code directly related to the issue that were germane to the ticket, not agricultural production, that are directly germane to the ticket, that your client could also avail himself under the code, and he hasn't done that.
I would just add to that point, though, in the intervening years from the issuance of the ticket, we had the other case with Dalia where Ag and Markets said that the importation and creation of the mulch is considered an accessory use to an agricultural production. So I think that's the bridge we're looking to follow through. And I think that's the reason that that's in this presentation. That was an undetermined fact. Ag and Markets had not yet, and we were through a protracted legal process in that case. Ag and Markets had not made a final ruling as to whether or not the stockpiling, importation, and creation of mulch is an associated agricultural product. And that has been recently determined, and that's why I think we can bridge through the issue that you're suggesting, that at the time, it wasn't decided, and at the time that the ticket was issued, Ag and Markets had not ruled on that, and we had been in process, and we had requested the zoning board to have this determination made while we were in the process. And again, we are availing ourselves of the site plan process with the town. The issue that's before this board is the issuance of the ticket, which has created a stop work order, which is the subject of an enforcement action in village court, in town justice court, and was previously the subject of a rather recent litigation in the Suffolk Supreme Court. So we are here to try to preserve the rights of the farmer to do things that are agricultural and agriculturally associated with. I mean, that's why we're here tonight, and that, I think, ties us back into the issuance of the ticket. That's
I
my,
don't think it ties it to the ticket.
okay, we may disagree.
Okay.
And we can also supplement that if you'd like.
So can we get to your alternate theory?
Yes. That would be Exhibit 27, which is the case decided in the Fourth Department. This is the matter of Interlakes versus the town of Ticonderoga, and I won't, belabor this presentation, but in essence, it's a short decision. You may or may not be familiar with it, but this, you are familiar with it?
Yes.
Okay, so then it stands for the presumption that a zoning ordinance cannot be written, this is the alternate sign of relief, a zoning ordinance cannot be written to prohibit agricultural activity. So in the event that you do not want to find the vested right of continuous agricultural use, state law in this particular area preempts the town from prohibiting agricultural uses in an agricultural district regardless of the zoning, is what this case stands for. So that's our alternate term of relief that we would seek to have this board.
Well, I'm holding you to your request for relief. Your ultimate request for relief cited. Alternatively, based upon the determination of ZBA number 09-58.
Right, and to that point, it was for this board to acknowledge its precedent that a use that was formerly an industrial A was grandfathered with those vested rights. So that would stand for the presumption that under the industrial A, again, taking aside the issue that we're in an ag district, which is not something to be taken aside lightly, because the reason for that alternate relief of the prior zoning under industrial A gets us also into the agricultural use, which once you establish the agricultural use, the reasons that this ticket was written has now been determined by the state of New York to be an associated agricultural use, which gives you then the authority to, through the record, and again, the record that is being brought before this board can be supplemented and has been supplemented today with the case citation that we just cited to about the Ticonderoga case, which is the, I'd call it the third or reinforcing alternative relief that we're seeking, that agricultural use in an ag district cannot be prevented by a town zoning ordinance, and therefore, under that concept, the ticket could not have been written against the activities at the site that were associated with agricultural production. That's how I put it all together.
Okay, a few questions.
Yes.
ZBA number 09-58, different piece of property, correct?
That is correct.
Also, that zoning board of, let me back up. That zoning board application dealt with a site plan that was submitted in 2001, before the change of zone under the recent comprehensive master plan of 2003 and 2004, correct?
That is correct.
And that zoning appeals determination did not involve agriculture. It involved an industrial use called a building trade shop. True?
That is also correct.
And related thereto, as accessory to the building trade shop, the applicant was requesting outside storage of material. True?
That is correct.
Nothing to do with agriculture.
That's not the reason it was brought as an example. The reason I brought that example, just to be clear, is that this board in the past has granted vested rights. I don't understand it's a separate
That
property.
predated the change of code, zoning code that you're even referring to.
I don't understand that, but I think if you take,
They had a filed site plan in 2001.
no, I'm very familiar with the file,
Okay.
yes. But I think this may not all line up in a very linear way, because this is not a linear application, but there are reasons to make the record before this board to show of its prior precedent. The issue that you're referencing in that case was a finding by this board of vested rights under an older zoning classification. We also were under that older zoning case. It was not the same use, but agricultural uses were permitted in the industrial A. That's the rationale and the reasoning to say that you have in the past granted vested rights under a prior zoning district. It happens to be next door. It just happens to be next door. But the premise is that this board has already found vested rights of prior uses that were permitted under the older zoning. And that's the only reason for the case. I'm not trying to link them in any other way, but for the fact that precedent has been set by this board to grant vested rights under prior zoning codes, which this board has done in the past as well. This one seems to be a very close comparison in a way that,
But it's a provision in our code.
I understand that.
If you can demonstrate it, but it's apples and oranges with respect to this application and the one dating back to 2001.
Correct, they are apples and oranges in the sense of the uses, but the concept of going back, and it's again, the discontinuous.
And the dates of predating the code.
Right, but at that time, site plans were not required either for farming activity, so I think, we didn't have to have a site plan submitted to continue an agricultural use. I mean, I think if you bring it to its full, that's the concept, that's the rationale, and we can always outline it more fully if you'd like it briefed, but that's the reason for that there. It wasn't for any other purpose than to prove that this board has granted vested rights under prior zoning districts. But again, to hopefully not belabor the point, but I believe that I have, the issue again really turns on that this property is in an ag district, and the zoning code cannot be applied against it for agricultural uses, which have now been determined by the state to include outdoor storage of the soil and the mulching on the subject property, which is really the essence for what, and for the importation, right? If you read through the decision and you read through Ag and Market's order, the Dalia Farm was importing material to create topsoil, and they were importing processed mulch to be sold with the product. And that is what we're seeking this board to amend the ticket that was written, so that those activities, the stockpiling of soil and the stockpiling of created compost and mulch can be stored on the property as an accessory use to an active agricultural property. And that's, in essence, what we're asking for tonight. And obviously, we have anyone from my side who would want to ask any questions of, we can obviously answer any questions from the audience if there are any, or I'll take any questions that you may have.
Any of the family members want to get up? Please, step up. And if you kindly raise your right hand, do you swear to tell the truth, nothing but the truth, so help you God? I'll tell you what I'd like to know is family history.
Yeah, good
Give
evening.
it to me.
My name is Steve Mazaneski. My address is 35675 Main Road, Orient, New York. And the subject property that we own is 3795 Middle Country Road. The Mazaneski family immigrated to Waynescott, New York in 1917. My children are the 5th generation out here. My grandparents sold all the farmland in Waynescott long before I was born. My father was a police officer in East Hampton. My mother drove a school bus. 25 years ago, my wife and I saw what was happening in Waynescott and decided we didn't want to raise our kids there. We found a farm in Orient. We worked real hard. We purchased that farm. We ended up buying 3 other farm properties in Orient and combining it together for over 150 acres of farm production of nursery stock, primarily privet hedge. We also have horses boarded there. We have hay fields, and we've been farming that property since we purchased it it was about 18 years ago, 19 years ago. We work 7 days a week. I've heard over and over again in Riverhead Town, you're not a real farmer. And we're getting kind of tired of hearing that. You know, we work nonstop. We wanted our kids to own farms and have farms. We have over 150 acres of ag production, pure nursery stock ag production. The way the Department of Agriculture looks at it is they look at all your different farm properties and put it together as one large entity. We have Driftwood Farms in Orient, DW Farms, we have Driftwood Family Farms in Calverton. Calverton property, we purchased that in 2012. We came to the town and we made a proposal that was drawn up. It was Alan Connolly with Department of Agriculture, not Department, it was Cornell Cooperative Extension. Did a complete comprehensive plan, working together with Tom Wolpert. We spent a lot of time and a lot of money. Peter Danowski was our attorney at the time representing us. We came to the town with a plan. That plan entailed, like Neshi, you see it here, entailed removal of about 400,000 yards of sand from the property, which at the time was permitted under the agricultural law. The application was made, it was held by the town for 8 months. They changed the law, and the day after they changed the law, they accepted my application and denied it.
How much money did you pay?
For what?
Yards of sand?
Nothing, because
Nothing?
we never did this.
Okay.
They denied the application, which you were speaking about earlier. So we spent all this money, we did all these comprehensive plans I mean, you can see this would be a level, beautiful farm field, and we'd be using it. So, okay, we were railroaded and we were told, you're not doing agriculture there, you just want a sand mine. So we said, all right, we will farm the property the best we can and utilize it with our other farmland and farm production. And part of that was making soils. When we dig in a lot of privet, every 2 years, we dig privet, we're taking all the soils out. We produce the soils here, we take the mulch compost, we grind it, we screen it, let it sit, we truck it out, we put it in the farm fields, and we spread it out, till it into the soils to enhance the soils. And we've been utilizing this farmland up here the best we can with what it is. I mean, it's hills, it's slopes, it's trees, it's, the town attorney wrote up a report stating that we were only farming 12 acres, which is probably about right what the open farm fields that are there. But then saying the additional 32 acres are nothing but a commercial mulching processing facility, which that is not a true statement considering the other majority of the property is woodlands. There is a small 4 to 5 acre portion that we do the processing of agricultural soils. So, back in 2012, the same Mr. Downs came and issued us a summons for importation, exportation of the same exact thing that he, word for word, that he did now. Mr. Dowski came in, we made a determination that he's doing this for agriculture. Everybody was fine with it. We've been doing it, the same exact thing for the past 12 years. No one said a word. There was, unfortunately, a mulch fire there last year. My fault. You know what? I had so much going on, my fault. And I've just been getting bombarded since then. I just want to farm. I just want to utilize my property for agricultural purposes. And as far as being told that we didn't farm it in 2012, my words are a statement in something. Here are photographic documents of 2012 when we purchased the farm, of the farm is just plowed and planted with ryegrass, and you can see everywhere that it washed out, and that's the reason Alan Connolly did a full comprehensive agricultural site plan for this property.
Have you turned that paperwork in yet?
What's that?
Have you given us that paperwork? Do we have all that?
You got it in 2012? I don't know. Have you given it to him? I just remembered I had these sitting in our old paperwork,
Okay.
so I just pulled, I mean, if you want to look at it quick, you can. These are.
If you can get us copies of that, it doesn't have to be tonight.
Okay, but I just,
Get us copies.
you know, we're really having a hard time here that everyone says, we want farms, we want farms. Well, they want farms as long as it's a pretty field that has nothing going on in it. You know,
Can I
Yes.
ask a question? The materials that you use there,
yes, sir.
export,
Yes, sir.
do you sell any of that?
I do sell a portion of it to people, same customers that purchased our privet hedge and our trees, and it's an accessory sale to our agricultural products.
So you,
And I do have trucks there with my other business that I utilize in the farming business, and we use it all. It's one big family business that, you know,
so
we're
do you
trying the
sell it
best
to
we
any
can. I mean,
commercial entities or other farmers?
what's that?
Do you sell it to commercial entities or to other farmers?
Matter of fact, I sold a whole bunch of it to Ricky DeLeo this past spring. So, it goes out to my farm, a bunch went to Ricky's farm, goes to other farmers, it just, you know, and then people who purchase trees and shrubs from us, we sell to them too. So, it's an accessory use to our agricultural, you know, everybody's looking at this one piece, but they're forgetting about the 4 other farms we have that work together in conjunction with this farm. You know, if they were all right next to each other in Riverhead, yeah, they're gonna be like, wow, that guy's got a huge farm, but they're not. The majority of the farm is in Orient, and we have this portion up here that we utilize too.
Thank
So,
you.
Thank you very much.
Anybody else on the board have a question? Okay. Anyone else that want to get up, speak? Tom? No? Counsel, you have anything else to add to things?
No, unless there's any comments from the public, I think it was suggested to keep the record open. We can submit additional documentation to the extent necessary, and I really thank you
Great.
for indulging me in this application.
Thank you very much.
Thank you.
Anyone in the audience to have to be heard on this matter? Anyone on Zoom? Zoom out. Okay, let's,
Keep it open for one
Oh, yeah.
for additional
Right.
documentation.
right. So we're gonna keep this open for the next meeting,
Okay.
and we'll take it from there.
Thank you very
And when is the next meeting?
It is
September 28th?
28th.
September, let's hear a motion. sports fans.
Mr. Chairman, I move that the appeal of 2023-035 Driftwood Family Farms LLC be adjourned till September 28th.
Second. All right. Mr. Bonds.
Aye.
Mr. Gazillo.
Aye.
Mr. Whitmire.
Aye.
Mrs. Zawiski.
Aye.
And I vote aye. So see you folks next meeting. Thanks very much.
Thank you, guys.
Thank you.
Appeal 2023-042, Pinchas Yusupov, 3 Taconic Court, Wading River, Suffolk County Tax Map Number 600-115-1-10.17, RB80 zoning, proposed carport, 24 foot by 41 feet. This appeal has been remanded back to the building department due to oversights and errors in the determination.
Anyone here to be heard?
I am in opposition,
Wow.
but it's being remanded, so I guess I say what, right?
Yeah, it's being remanded. So it will more than likely appear on the calendar again. If the determination is corrected, it could be the 28th. If you want to leave your name and email address, we can make sure you're notified.
So there's nobody here representing those folks? Okay. Give me your number and we'll take it from there. Sorry for the inconvenience. But we'll see.
You can state it on the record, right?
Sure.
Make it on the record.
Well, first off, we have to tell you if you're telling me the truth or not. So raise your right hand, do you swear
I'm
to
an
tell the
attorney,
truth, nothing but the truth, so help you God?
I swear to tell the truth, the whole truth, nothing
State
but
your
the
name
truth.
and your address.
My name is Chadwick Breedis. I work for Van Cott Ebrahimi PC, 1600 Caleb's Path, Suite 116, Hauppauge, New York, 11788. Phone number 631-939-2314.
Awesome.
Thank
Well,
you.
thanks very much for
Thank you
showing
very
up,
much.
and we'll see you next meeting.
See you next one.
Awesome. Thank you.
Okay, Appeal 2023-045, Carolyn Lotito, 155 Fire Lane, Wading River, Suffolk County Tax Map Number 600-37-2-1, RB80 zoning, legalize additions to residence. Applicant requests variances and a relief from Chapter 301-31, where proposed side yard setback is 6.8 feet, minimum required is 30 feet. Chapter 301-31, where proposed combined side yard setback is 20.8 feet, minimum required is 65 feet. Chapter 301-31, where proposed rear yard setback is 28 feet, minimum required is 75 feet. And Chapter 301-31, where proposed impervious surface is 37%, maximum allowed is 15%.
Good evening, Mr. Cuddy.
Good evening. Charles Cuddy for the applicant. I have an office at 445 Griffin Avenue, Riverhead, New York. Karen Lotito bought this property for her son several years ago. The property, if you look at the surveys, is an 8,000 square foot lot in a very cumbersome design. The house that is presently there was originally about 800 square feet. So when you look at this lot, it's 1/10 of the RB80 requirement. And basically, anything that's done in the lot, including the existing house, would require a variance. David Lotito, during COVID, started improvements without permits and is before the Justice Court now. And so they're going to pay a fine for doing it, but he would like to finish what he started. He has his daughter living in the house. They have essentially an 800 square foot house that they've tried to make into a 1,200 square foot house. The neighbors on the south side are a small house also on a small lot, virtually the same setbacks as this particular house has. The neighbor that's behind him has a stockade fence and has a house that's practically 100 feet away from the backyard line. So what they're asking for is to try and use the house with the various variances that are needed to finish the house and give them a 1,200 square foot house for two people. I don't know that there's any alternative they have because of the size of the lot and the existing size of the house. Certainly, residentially, this is not an adverse environmental condition that's created. And certainly also, I think that it's not adverse to any of the neighbors. As I say, the neighbor on the south side is virtually the same. One thing I just would point out to you, you have a survey that may be somewhat difficult to understand because each of the owners along the fire lane own right to the center line of the road, and that's what's shown on the survey. But even with that, it's still an 8,000 square foot lot with an 800 square foot house. So I would hope that the board would permit them to finish what they started and grant the variances. The impervious surface, as it presently is about 15% to 20%. It really isn't changing anything on this lot very much. So again, I don't believe that the variances they asked for hurt anyone, and they're the only kind of way you could build on this lot. I don't have anything else further to say.
No, you shouldn't. Yeah, that's a crazy place down there. I'd love to get the guy that drew up the maps down there for housing.
There are 11 houses.
That's another story.
There are 11 houses that have the same configuration right on the road.
Exactly, so. Is anyone in opposition of this appeal? No. Anyone on Zoom? Let's have a reading, please.
Mr. Chairman, with respect to appeal number 2023-045, I move that the appeal of Carolyn Lotito, 155 Fire Lane, Wading River, Suffolk County Tax Map number 600-37-2-1 in Residence B80 RB80 zoning for variances and/or relief from Chapter 301-31, where proposed side yard setback is 6.8 foot, minimum required is 30 foot. Chapter 301-31, where proposed combined side yard setback is 20.8 foot, minimum required is 65 foot. Chapter 301-31, where proposed rear yard setback is 28 foot, minimum required is 70 foot. And Chapter 301-31, where proposed impervious surface is 37%, maximum allowed is 15%, be granted in accordance with the applications and sketches with amendments thereto, if any, as filed with the building inspector.
So moved.
Mr. Barnes?
Second, you gotta need a second.
Whoop,
Second.
thank you.
Aye.
Mr. Barnes? Aye. Mr. Gazillo?
Aye.
Mr. Whitmire?
Aye.
Mr. Zawiski?
Aye.
And I vote aye, so Mr., you got it.
Thank you very much.
Have a nice night.
Thanks.
Good luck.
Appeal 2023-046, Kevin Barrett, 1 Oakwood Drive, Manorville, Suffolk County Tax Map Number 600-146-1-22.6, Natural Resource Protection, NRP zoning, proposed 1,925 square foot addition to residence. Applicant requests variances and/or relief from Chapter 301-179, where proposed front yard setback is 25 feet, minimum required is 100. Chapter 301-179, where proposed side yard setback is 16.5 feet, minimum required is 50. And Chapter 301-196, approvals needed from Central Pine Barrens Joint Planning and Policy Commission.
And if you kindly raise your right hand, do you swear to tell the truth, nothing but the truth, so help you God?
I do.
State your name and your address.
Robert Stromsky, I reside at 44 Circle Drive in Jamesport. I am the architect for the owner. As you see here, we've presented an application for a one-story addition, 35 by 55, housing primarily a two-car attached garage and additional living space to an existing one-story structure. The addition proposes a one-story structure. We feel that this lot, the variances that are being sought of a 25-foot front yard, the way that the building inspector is interpreting it, as you can see, if you visited the site and you look at the site plan, it's not a very conventional lot as to say what is really the front yard, the rear yard, the side yard. So in the way the property is used, what is being called the front yard essentially is almost the side yard, because there's a property directly to the east where that 25-foot setback is. It also happens to be where the right-of-way access is to the site. So I guess the way that the map was written is that was considered a front yard, but, so we're here asking for a 25-foot setback from that front yard, which in all practical purposes is almost more of a side yard, the way the property is actually laid out with the adjacent property. Beyond that, we have received approvals from the Central Pine Barrens. Basically, there was a letter, I believe it was handed in with the application, so you should have that as record. Also, I have the affidavit of postings and mailings and the pictures of the signs. The day it was posted and also today. There was a letter written back in December 15th of 2020 from the Pine Barrens, basically stating that as to their regulations, that in addition to an existing residence would not be a regulated activity, so they don't have any issues with the proposed project as it's being sought. There was also a permit granted pursuant to New York State Environmental Conservation because the property is within the Wild, Scenic, and Rivers Act. So there was an application made to them by the client, and that was also approved by the DEC. So at this point, in order to move forward, we're requesting that the board look at our project and understand that what we're asking for is pretty common in the neighborhood. We're not really asking for anything beyond what would be customary to the neighborhood and aesthetic appearance and size with respect to the setbacks. And at that point, if there's any questions from the board, I'd be happy to answer them.
Board members, anybody have anything?
The right-of-way,
Yes.
Oakwood Drive, how many homes are on that right-of-way? Approximately.
I have no idea. I mean, do you?
Yeah, it didn't look like a lot, about 13 homes.
I guess, yeah, 12 to 13. There's people in the neighborhood, so they're, could
Okay.
attest to the
And does
neighborhood.
everybody own, have rights to the right-of-way, those homes?
I believe so.
Sure. You know.
Sorry, I'm not the legal answer on the subject.
Okay. Please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and address.
Raymond Krieger, 31 Oakwood Drive in Manorville.
Go ahead.
A little history on this. Georgie Eggert and Artie Seaman were displaced by the Grumman facility. Together, they were farming together. Together, they bought this strip of land. Artie had one side, George had the other. George offered to put in a 25-foot by the whole length of the road right away, so that the utilities, such as the telephone poles, could go on. People on the other side have the right-of-way written into their deed, that they have to allow ingress and egress for the people further down. Robert and Lois Smith owned this parcel before Kevin did, Mr. Barrett. And what happened was that she came before the zoning board in order to break off another lot, this house, for her son to build on. The zoning board, in order to make it appealing to the zoning board, she had to draw this odd angle, and then George Eggert deeded the 25-foot right-of-way over to Robert and Lois to add on to that property. So technically, the right-of-way, Oakwood Drive, ends at their property line. It doesn't go through to the county land like it used to.
Okay, so that transaction basically dead-ended the road, shortened the road.
Shorten the road from ending at the county property
Okay.
to ending at their property line.
That's a great explanation, thank you.
All right.
Yes.
Thank you. Is there anyone else in the audience that would like to make a comment on this? How about Zoom? Is anyone on Zoom listening? Oh, I'm sorry. Wait.
Claire Bennett, Oakwood Drive, Manorville, New York. I just want to say.
Wait a minute.
Okay,
Time out.
yeah,
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Claire Bennett, 12 Oakwood Drive, and I'm a neighbor of Kevin and Jenny's and Ethan, and little Elizabeth over there.
We don't need your family heritage.
No,
but
it's
go ahead.
theirs. It's their family heritage, and I'm very happy for them, and I hope you approve.
Thank you.
Well, thank you very much. It's not what we're used to when people come up to the microphone, but thank you.
I don't think anybody answered me on Zoom, Mr. Chairman.
Does anybody else?
Let's have, anyone else to be heard on this matter? Although I think we've heard enough.
So we also, there was a request by Dunn Engineering.
Oh, okay.
Wait,
Oh, sorry.
There was a request by Dunn Engineering on behalf of the neighbor at 4 Oakwood Drive to keep it open for additional time to review and comment.
Who is it? What's the name?
Number 4 Oakwood Drive.
Okay. So we'll put you off to the next meeting, and we'll take it from there. Unless somebody else has anything to say? Nobody else? Okay. Now, who's this next door neighbor?
what's here? Did you look at that letter?
Yeah, that's why I was asking questions about the right of way.
Okay.
Fine.
Why do we need to hold it over? Is there a push to hold?
Okay, so let's hold this off to the next meeting. Let's hear a reading. Move it on.
Okay, I don't know who has it.
Do I hear a motion to move it to the next?
Yes, so made.
Move it to September 28th, adjourn.
Second. Mr. Bonds?
Aye.
Mr. Gazillo?
Aye.
Mr. Whitmire?
Aye.
Mr. Zawiski?
Aye.
And I vote aye. Okay, you guys are the last of the Mohegans. Let's see what you got.
Appeal 2023-047, Martin Zuzullo, 71 Green Street, South Jamesport, Suffolk County Tax Map Number 600-92-2-40, RB40 zoning, proposed one-story addition, new deck and porch. Applicant requests variances and a relief from Chapter 301-17, where proposed front yard setback 28.7 feet, where minimum permitted is 50 feet, and Chapter 301-17, where proposed side yard setback 9.1 feet, where minimum permitted is 25 feet.
All right, are you an attorney?
I'm an attorney. Good evening and good to see
Well, then
everybody
just
again.
your
It's been a
name and
while.
address. Be wonderful.
My name is Michael A. Kimack. I'm P.O. Box 1047 in Southfield, New York. I represent the Zuzullo, basically. It is a quarter-acre piece of property with an existing dwelling on it, and it's somewhat skewered, and it's presently sitting back 28.7 feet. The existing dwelling is a 932 square foot, one-story house, has 2 bedrooms in it and a full basement underneath it, no finish at all. They would like to be able to expand it in a reasonable fashion going back, because it kind of ties into the same lines going backwards, which would add an additional 815 square feet for a total of 1,747 square foot. It's existing 2-bedroom, and it would go to a 3-bedroom, and one of the bedrooms would be in the full basement down below. As a result of that, it's still a 1-story, some vaulted ceilings on the inside. As a result of that, the activity they have applied for, and we should be getting an approval soon from Suffolk County Health Department for a new IA system, IAWTS system in the back, to replace the cesspool that's in the ground.
Okay.
Do you have any questions of me? And we're the last Mohegan standing over here, so it was interesting.
That's not always good.
That IA system is pending, not yet approved?
We just are answering the last incomplete, it's close to it. It's technical, the questions were technical in nature. I've done enough of these to know that it's just a matter of just,
Okay.
crossing all the i's and all the t's.
All right, all those in opposition, please stand up, be counted. Anybody on the Zoom? There seems to be nobody in opposition, so let's have a motion.
All right, Mr. Chairman, regarding appeal number 2023-047, I move the appeal of Martin Suzulo, 71 Green Street, South Jamesport, SCTM number 600-92-2-40RB-40 zoning for variances and/or relief from Chapter 301-17, where proposed front yard setback is 28.7 feet, where minimum permitted is 50 feet, in Chapter 301-17, where proposed side yard setback is 9.1 feet, where minimum permitted is 25 feet, be approved in accordance with the application and sketches for amendments thereto, if any, as filed with the building inspector.
So moved.
Second.
Thank you. Mr. Bonds?
Aye.
Mr. Gazillo? Mr. Whitmire?
Aye.
Mrs. Zawiski?
Aye.
I vote aye.
Thank you very much, gentlemen. Nice
So
to
your
see you
bill has
again.
been granted
It's been a
and,
while.
Good luck.
You got a great little spot down there, so enjoy it. Okay, gang,
Thanks, have a great evening.
great, you too. Okay,
Okay, and then we have appeal 2023-048, which was originally on the agenda for this evening. It will not be open due to change in relief being requested. This appeal will be renoticed and heard on September 28th, 2023.
okay, so I don't have to read this. I move that the appeal 2023-038 for AD Enterprises, 426 West Main Street and 126 Squeezy Avenue, granted on August 10th, 2023, be vacated, and that a reserved decision be made after the SEQA process has been completed by the town board as lead agency.
So moved.
Do I hear a motion? Second. All right. Mr. Bonds?
Aye.
Mr. Gazillo?
Aye.
Mr. Whitmire?
Aye.
Mrs. Zawiski?
Aye.
I vote aye. Do I hear a motion to accept the minutes for the last meeting?
So moved.
All in favor?
Aye.
Do I hear a motion to adjourn?
So moved, Mr. Chairman.
All in favor?
Aye.
Thank you very much, everyone, and good night.
Guten Tag.
Guten Tag.